First of all, I want to just welcome everyone, and I really appreciate that everybody's signing on. My name is Mark Buckhalter. I'm one of the members of the Community Association Resource Group, affectionately called CARG, C-A-R-G. CARG is just a consortium of various disciplines and services that cater to condos and HOAs. We put on live and also Zoom educational seminars. I think really at first, I really just want to express on behalf of the COG members, our prayers and our condolences to the tragic events that happened at Champlain Towers. One of the towers actually is one of my clients. I'm sure everybody in the community knows someone or someone that knows somebody. So again, there's no words to express, but all our prayers and condolences are with those that are affected. Very quickly, what I would like to do is just mention just the various disciplines, because we have a very large agenda to talk about, and I don't want to take away from that. COG actually has probably about 10, 12 disciplines that every community obviously needs, and we're here to help them with. One is obviously banking from Center State, there's Terry Russo. There's cable consulting with Marcy. There's fire, water, mold cleanup, Serpro. There is our insurance agent from Legacy Insurance. We have janitorial and light maintenance with Craig. Our founder is probably Charles Infantino with the GRC Landscaping. We have paving, seal coating, and paving. We also have a pool service that crosses over Dade, Broward, and Palm Beach counties. We have a public adjuster, Kathleen is on the phone. We have a roofing with Paul Baines Roofing. And obviously we couldn't do all of this without Jeff, who's from Support Depot, who started off the program. This morning, we were very fortunate to go ahead and to have Michael Bender from Kaye Bender Rembaum. I've known Michael probably for about 20 years. Probably most of all of you have seen him at trade shows as a guest speaker. I don't want to call him, he's one of the old timers, but experience-wise, he's one of the old timers. It's not a situation that you can go ahead and ask Michael a question and normally he'll have to go ahead and say, well, I have to research it. The wealth of knowledge that Michael has and his partners is, he's really just one of the foremost condo attorneys, in South Florida. Pleasant guy to deal with. I know this is a little bit of a sales speech, but it's meant wholeheartedly. He's just, one of the nice guys to deal with, and very, very knowledgeable. So really, without further ado, because we do have a lot to cover on this session, I want to just turn it over to Michael, and just to announce to everybody that after Michael finishes and concludes his portion, and you have any questions that he can answer, the rest of the CARG members will stay on. So if you have any questions that are specific to any of those disciplines, please feel free to go ahead and to use the Q&A, and we'll answer as many questions as we can. Michael, again, thank you so much for being with us. It's really it's a privilege and it's an honor, for you to go ahead and to be one of our guest speakers. So
you're very kind, sir. You're very kind. Thank you, Mark, and thank you to all the sponsors, co-sponsors with CARG, and hello to everybody who's joining us this morning. Obviously, just to add, obviously, it would be disingenuous for me to say that we aren't all thinking about what's going on down at Champlain Towers, and I will say shortly, sometime in the next hour or so, we will be sending out an email blast. All of you who are on here will receive it, and it will have a link that was put out today by the Sun Sentinel and Miami Herald with ways that if you want to help everyone impacted by the tragedy down at Champlain. So please do look for that. And everybody, well, I'm sure we're all keeping them in our prayers. So now, unfortunately, I have to transition to, I told them, I said, this transition is going to be awkward, but I do want to say again, good morning and hello, everybody. Mike Bender with Kaye Bender Rembaum. Very, very briefly, for those who don't know, we are a law firm that does specialize in representing Florida's community associations. And we have 20 attorneys. 9 of us are board certified specialists in the field of condominium plan development law, myself included. Our offices are in Broward, Palm Beach, and Hillsborough County. We also do have offices by appointment in Miami-Dade County. We are very active in publishing articles, legal morsels written by my partner, Robert Kaye. Most recently, in fact, we put an article out which was very, very pertinent regarding one of the bills I'm going to talk about today, Senate Bill 56 and the new collection procedures. So if you are on our blast list, I would encourage you to go back and look at that article. It's also on our website at kbrlegal.com. Jeff Rembaum, my other partner, publishes Rembaum's Association Roundup, which has also got a great number of articles on news, condominium association news you can use. We have Robert hosts a monthly radio show. Peter Mullengarden does a weekly radio show. And for those of you who are not aware, I am honored to be the chair of the Florida Legislative Alliance, which is the legislative arm of CAI, Community Associations Institute, and working with 20 other volunteer delegates throughout the state who cross-reference of industries, where we are attorneys and insurance agents and bankers and CPAs, property managers, homeowner volunteer leaders, and on and on and on. And we work with our lobbyist, Travis Moore, and our CED, Emily Jennings, great group of people. The delegates are all volunteers. Obviously, Travis and Emily do their jobs. And we work together to try to help provide good legislation for us here in Florida and fight off. We play a lot of defense. And that's a good lead in to what I will be talking about for the next 45 minutes, which is just some of the pieces of legislation. I think it was mentioned, but this is a brief legislative summary. This is not your legislative update. The 2022 legislative update, which does review all of the laws that were passed in 2021 that have impact on community associations, is a course that is yet to be approved by the state. Once it's approved, obviously we'll be offering, that's a minimum 2-hour course. Today, we're going to take 45 minutes. I want to highlight 4 or 5 pieces of legislation just to give everybody a flavor at a minimum of what's gone on. Some good, actually quite a bit good. Unfortunately, some not so good. The good, the bad, and the ugly, as we say. So I want to again thank everybody. And like I said, for the next 45 minutes or so, I'll be talking about a few bills. If you have questions pertaining to the legislation that I'm discussing, by all means, please throw it into the Q&A. And if I can get to it, I will do my very best to do so. With respect, if the questions that you're posing are unrelated to the legislation that I'm talking about, it's unlikely we'll have time to address those today. Okay, so the first bill I want to get started with is the COVID-19 immunity. Stephen, thank you, by the way. I was wondering about the sound, so I appreciate that. Good. The first bill I want to get review is the COVID-19 immunity bill, which is Senate Bill 72, which is actually now Chapter 2021-1, because it was the first bill that was signed by the governor. It took effect March 29th, 2021, and it created a limitation of civil liability stemming from COVID-19. It set a statute of limitations of 1 year, and it requires good faith, substantial compliance with government-issued health standards or guidance. And the key here is it applies to business organizations as defined in the statute. And I will say that as the chair of the Florida Legislative Alliance, Governor DeSantis created a task force last July called Reset, and it was a way to reopen Florida's economy. And he tasked business leaders throughout the state with coming together to put proposed legislation in place. In large part, Travis Moore, the aforementioned Travis Moore, the lobbyist for CAI, knew the chair of that committee, William Large, and told William that if you're going to be putting together business leaders, you need to have a representative of community associations. As you all know, we are not for profit, but we are corporations, and we are businesses. And in fact, our businesses impact many businesses. In fact, all of our sponsors today are impacted by the business of the corporations, my firm included. And so I had the honor of being getting a seat at that table on behalf of community associations. And when I sat down at that table, proverbial Zoom table it was, I noticed the proposed legislation that all these businesses were talking about, the large for-profit industries throughout the state, didn't even reference community associations. We were left out of it. So without getting into a lot, there was not a lot of pushback from the other businesses, but it was just not on their radar. So I'm pleased that I was able to get to that table, and we were able to get community associations incorporated into the definition of business organizations, so that this COVID liability, this protection does apply to community associations uniformly, because it does apply to all not-for-profit corporations. So that is the COVID-19 immunity bill. It's Senate Bill 72. That does have that is now chapter 20-21, 2021-1. And it is, I think the most important aspect, which I will reiterate, is it greatly limits the liability. It's not quite an immunity, if you will, but it's just about. It will require an individual to have a very high level, burden of proof, if you will, to show that the association was overwhelmingly negligent in failing to substantially comply with government issued health standards or guidance. And as most of you probably know right now, the emergency, or the state of emergency, is supposed to expire in the next couple of days. We don't know if the governor is going to extend that any further, but there are no county orders. There is no governmental orders in place right now. There's CDC guidance, which is all we have. And some argue that I think the CDC guidance is not a governmental mandate. It is recommendations. So if as you are continuing to open up your facilities, I think it's important that you continue to do your very best for your communities. If you still if you have high levels of at-risk population, masks are still permitted inside. If you have rules that you've adopted, continue your proper sanitization, and just be smart about, as we keep beating, it looks like we're turning the corner greatly on this pandemic. So we just keep going with that. But the liability exposure to associations has been greatly limited. And obviously, as I always say, talk with your insurance agents and make sure you have a level of comfort in signage you're supposed to post, and how you're conducting your business in that regard. But it's an excellent bill. Community associations were included, so we're very happy about that. The next bill I want to touch on is, and then I'm going to come back. Steve, I'm going to come back to Senate Bill 56. I will definitely be talking about that. I consider that the ugly, by the way, in my good, bad, and ugly. But I want to talk a large part of the next of my conversation. I want to talk about Senate Bill 630, which was recently signed by the governor. It takes effect July 1st, 2021. I do not have the chapter, I'm sorry, in front of me, but it is Senate Bill 630. It's 101 pages. And it has an enormous amount of information that impacts community associations, condominiums, sprinkled in cooperatives, as well as HOAs. And this was a bill which has a lot of pieces that we at FLA, Florida Legislative Alliance, had been working on for 2 or 3 years and had been trying to get approved by the government, by the state. And so I'm pleased to see that some of these things went through. They didn't go through all of them the way I would have preferred, the way we had drafted. And I will touch upon that more specifically as I go through them, but we did get a lot of good things. We did have to do some compromising, only because, in particular with HOA lease restrictions, which I'll get to, only because that was going to go through with or without us. So we wanted to make sure if it was going to go through that we at least had some protections in place for our HOA communities. So I'm going to talk about Senate Bill 630. And no, I'm just going to go through different items and in no particular order, but I'm just going to go through them and highlight many of the aspects of it. The condominium unit owner insurance policies. So there was this is a piece on subrogation, and I'm no insurance expert, but essentially subrogation is in my simple terms is where one insurance policy seeks to get reimbursed from another, either another insurance policy or at least from another entity claiming, hey, we paid out a claim, which is your responsibility. And so we want to subrogate. We were looking to subrogate against you or your policy and have you reimburse us. And what this provision does now says if the association's insurance policy does not provide the right for subrogation against unit owners in the association, an insurance policy issued to the unit owner may not provide rights of subrogation against the association. So it's basically a reciprocal situation. So you have a master policy at the association level, and it's for condominiums. I'm sorry, and I apologize. Let me clarify. Unless I specify otherwise, the bills that I'm talking about, the language in the bill I'm talking about applies across the board, but what I will do my very best is to let you know if this applies strictly to a condominium 718, or whether it also applies to the 719 and or 720 situation. In this case, I'm talking specifically the condominium unit owner insurance policy. So you have a master policy in place. And if the master policy does not have the right to subrogate against a unit owner's HO6 policy when the unit owner is the party responsible, and the masters had to pay out, then the unit owner's policy may not subrogate against the association's master policy. Simple quid pro quo, and it really is a correction. It was something that several years ago, when insurance language was taken from the 718 and moved into a different section, the insurance section, my understanding is this got left out inadvertently. As I said, for multiple years, we've been trying to get this fix in, and it was approved. It does take effect July 1st. Also for condominiums, official records, it clarifies bids are to be kept for 1 year after you receive them. It further clarifies a tenant can inspect the declaration of condominium as well as the bylaws and the rules, not the articles of incorporation though, for some reason, just the declaration, bylaws, and rules. And it clarifies you cannot require that a member state their purpose for inspecting records. And that's something that was in the HOA Act, and it was added to the Condominium and the Cooperative Act. A big clarification confirmed the 8-year term limit in condominiums. Many of you may recall in the condominium world that in 2018 legislation was passed that said that you cannot, an individual may not serve more than 8 consecutive years unless they obtain at least 2/3 of the votes of those voting, or if there are not enough candidates. So if you have a 7-member board and only 7 people with their names in, you get your seat. But if for some reason you had 8 people put in and you had an election, if you were more than, if this was your 9th consecutive year, you would need 2/3 of those voting as opposed to just being a plurality. Well, when that was passed, there was a lot of confusion. Hey, does it apply now? Is it retroactive or is it prospective? Does it include prior year's service? Well, this firm from the get-go explained from a constitutional perspective, this is not a retroactive law. It applies only going forward. And many others in the community association industry agreed. The division through the DBPR issued a statement that said it did apply retroactively prior service initially. They did reverse that shortly thereafter, although I never saw them put that in writing. But for years, we'd been trying to get that clarified, and we did. So effective July 1st, it is clarified. The condominium term limit statute does not apply retroactively. It applies prospectively from July 1st, 2018. And I've had questions come up even recently, and I want to be very straight, very clear here. This term limit in a condominium will not have any impact, if at all, prior to 2026. Okay, so if in other words, if you've been on your board for 20 years already, none of those prior year service counts in this 8-year limit, other than any term that you were appointed or elected after July 1st of 2018. So that's why I'm saying it won't impact till 2026, because your first year would be 2018. And if you stay on the board continuously for 8 more years, that means in 2026, you will have served 8 years. Presuming that in 2026, this language is still on the statute, we'll see. It's at that point that if you have served uninterrupted, you would have to, the statute would apply, and you would have to then obviously get with your council and make sure that you, if you're having an election, what it is you need to do to stay on the board a 9th year, if that is your choice. But I want to make that clear. It has no impact before 2026, July 1st of 2026. Okay. Some other clarifications for condominium membership meeting. We clarified that condominium membership meeting notices, a notice of an annual meeting must include the agenda, and mailed or hand-delivered or electronically transmitted, posted on the condominium or association property at least 14 days in advance of the meeting. Obviously, if you have an election, you're doing in the condo, you're doing your initial first notice 60 days out. And then the second notice is anywhere from a minimum of 14 days up to 34 days. So just be aware of that. And it also clarifies that the notice of all other meetings, and sometimes you'll see my eyes go this way, guys, because I'm trying to see if you have, I'm trying to read questions as they come up, but I'm not sure that I don't want to distract. I don't want you to be distracted, and I want to get through the material. Notice of all other meetings other than the annual meeting also must include an agenda, be mailed or hand delivered or electronically transmitted. And by the way, the electronically transmitted is only if an owner has consented in writing to receive meeting notices via email. If you don't have those consents in writing, emailing out these notices is not compliant with the statute. You would still need to mail. You can send a courtesy email, but you would still need to mail it, have that affidavit of mailing on file in order to avoid a challenge that you didn't hold a proper membership meeting. For a member meeting other than the annual meeting, if there is no time frame in the bylaws, the notice must be provided at least 14 days. And this is something to clarify, which means if in the condo world, in the condominium, your governing documents provide that a member meeting is 10 days notice, you can use a 10-day notice provision, for example, to do a member meeting on amendments or to waive reserves. Candidly, when you're trying to, those member meetings are typically called because you're looking to get a vote of the members to support some board objective, which is hopefully in the best interest of the community. And even if it says 10-day notice, you're going to want to give as much notice as possible in order to allow enough votes to come in prior to the meeting. But again, and with these notice requirements, I say to board members, you can certainly go ask your manager what their opinion, because managers obviously are educated in this field. But with the change in the laws, and anytime we're talking about deadlines and those things, don't burden your manager. Let your manager reach out to council and get confirmation at least once, and then you have that confirmation going forward. It's a team effort there, guys. The manager gives you your business advice and can guide you, but they're managers. You should be letting your clients know, this is my thought, this is my opinion based on my education. However, it's a legal issue, and you should get guidance from your legal counsel. Okay, the next item, this is one that we had proposed, something that I thought was much more fair, having to do with condominium transfer fees. In the condominium world, there is the statute that provides for a transfer fee, quote unquote, which I think is better known as the application fee, but it is considered a transfer fee. And it is a fee that you can charge when with the sale or lease of a unit, if the authority to do so is in your declaration or bylaws. If you don't have that authority in your governing documents, and you should check with council to see if you do, then you need to amend your documents, or you should not be charging a transfer fee. As simple as that. If you are charging transfer fees without the authority in your documents to do so, and somebody brings a complaint to the division, you will be cited. You'll likely have to pay a fine, and anyone that has been paid, and then people may start, clamoring to get money back, which is a whole nother headache. So make sure you have the authority to charge these fees, or you can still do the application. You just can't charge, you can't properly charge the fee. Okay. So the transfer fee has been for years capped at $100 per applicant, other than it's used to say husband and wife or parent, dependent child, but you can only charge one $100 fee. And as you all are aware, with application fees going up, with a lot of out of country applicants, those fees are higher for background checks and things of that nature. The associations had been wanting to charge more so that they could at least cover the cost, not to mention the administrative costs, which management, properly charges if they're, management, if you're managed with a management company. So we pushed and drafted, we meaning FLA had drafted language that would have allowed for the admin charge to cap at 100 and charge the actual cost of the background check as set forth on the invoice from the third party background company. So it would be, if it was only $50, you paid $50 plus up to the whatever the admin charge. If it was $150, you paid $150. Well, there was a lot of pushback from the what I am told, a lot from the realtors and their very strong lobby groups. And ultimately we reached a compromise. The fee has been raised from $100 to $150 per applicant. And now it says, except for spouses, it doesn't limit to husband and wife, which I think is very progressive and proper. So it lists if it's either spouses or parent, dependent child, remain one applicant, which you can charge $150 if the authority is in your governing documents. And also the transfer fee will be adjusted every 5 years according to the Consumer Price Index, and that is the responsibility of the division, the DBPR division of condominiums. So we did get that increase. That's a good thing. It's not exactly the increase we wanted, but at least we got an increase, some movement there. And like I said, that was 3 years in the works. Very, very briefly, the electric vehicle charging station in the condominium world, they've now added or a natural gas fuel station that owners may install in their assigned space and limited common element space. If you have individuals who are looking to install electric vehicle or less likely natural gas fuel stations, then I would encourage you obviously to get with your association counsel or get association counsel and get proper guidance on the do's and the don'ts and how you can, because the statute is very specific as to what the association is permitted to do. You cannot prohibit it. You cannot create covenants that prohibit it, but you can have requirements in place that the individuals need to meet in order for them to be able to do these installations. And I would encourage you to get with counsel and get clarity on that in a written opinion, so you have something to rely on going forward. One item here, the authority of the Division of Condominiums to investigate complaints on official records has been expanded. They currently only have jurisdiction over access to records. So someone claiming, hey, you're not accessing, they didn't allow me to access, they willfully withheld records, wouldn't allow me to inspect when I made a proper request. That is something they've had jurisdiction over forever. And there used to be a situation where you give someone access, they would come in and investigate and they would not find certain records. And we, counsel, would correctly point out that's not the division doesn't have jurisdiction over that to investigate that, because that's not an access issue. That's a failure to maintain, which is still a potential violation if true, but it's a violation that wouldn't be investigated in the same manner. Well, that jurisdiction's now been expanded. So the division now will not only expect access, but also maintenance. And it's just, and for those of you, obviously managers on the call, your responsibilities to assist these associations with ensuring that they're maintaining all of the necessary records, official records as set forth in the statutes. And the division does investigate both condo and co-op. HOAs, the division's investigation is limited to elections and recall, so they don't have the records aspect, but there is a requirement to be maintaining official records in all three, 718, 719, 720, the condo, co-op, and HOA. Be aware of what your requirements and responsibilities are, and make sure that you are maintaining the records and providing access when statutorily required, statutory compliant requests are made. Okay. This next item is something that I think is a very, very, very good piece. This applies in the condominium and cooperative world. and it's has to do with the ability now to file for pre-suit mediation as opposed to just having to go to arbitration. Disputes involving condominiums and cooperatives that previously had to be filed with the Division of Florida Condominiums for arbitration may now be brought in pre-suit mediation. So there's an option to either file the petition or demand pre-suit mediation for certain disputes. The pre-suit mediation is for those of you in the HOA world, you may be familiar if you've had any disputes. The pre-suit mediation platform in Chapter 720 is what is being incorporated into 718 and 719. Again, in my opinion, very positively. And what it basically means is if there is a dispute, if there's a dispute that you would otherwise have had to file a petition for arbitration, you now, instead of having to do that, you can invite if there's a perceived violation, you can invite the alleged violator to mediate, to sit down with a mediator and work this out before having to get involved in any other alternative, in other arbitration or even court. And what we've seen in the HOA world is this pre-suit mediation process generally works very well in avoiding time-consuming and expensive litigation by getting matters resolved at an earlier point. It allows the parties to sit down informally. Well, it's formal mediation, but it is more informal than court, certainly, and allows people to maybe have some dialogue and hopefully set aside any personal issues and really address the issue at hand, which is the perceived violation or the actual violation, get it addressed in a way that everybody can at least be satisfied. And like I said, amicably as possible. So I would encourage everyone to be considering pre-suit mediation in the condominium and cooperative world rather than arbitration, at least initially. And that's something certainly we're going to encourage our clients. A clarity, by the way, for condominium, cooperative, and HOAs for elections and recalls prior to this, again, everything I'm talking about takes effect July 1st. Prior to that, if you had a dispute, election dispute or recall, you had to file with the Division of Arbitration. Now you have the option of also filing it in court if you so choose, and not have to go through arbitration. Okay. Emergency powers. Emergency powers was another big item that everybody was recognizing needed to be addressed. And this does apply across the board, condominiums, cooperatives, and HOAs. The reason this came up is, as you may recall, these emergency powers were incorporated into the statutes in post those hurricane years that we had in 04 and 05. Where we had, I don't know, 5 or 6, including Wilma, at least down here in South Florida. And for those of you in the central and northern part of the state, you also had a few others that were, I think, constantly hitting in the Tampa area. And so after that, there was emergency powers that were implemented in the statute, 718 condo, 719 cooperative, and 720 HOA, which allowed boards some discretion on meeting notices, on meeting requirements, on special assessments, on access to the certain aspects of the community, of the buildings, et cetera, that would be modified in if there was a state of emergency declared by the governor. The way it was drafted obviously seemed very much limited to the windstorm or weather type event and not to something like we've dealt with for the past 18 months or so with COVID-19. There was debate. I think many of us, myself, my firm included, who believed the emergency powers based on some other legislation, some other case law did apply and continue to apply. As the state of emergency still exists. However, there was unnecessary confusion. And there's, if we're gonna, we might as well take things away when we have these unfortunate, and I don't mean to belittle it, unfortunate is an understatement with COVID-19, but when we have these situations like a COVID-19 pandemic, if we can't learn from it, then we're obviously doomed to repeat everything. So we want to learn everything we can in every aspect. In the community association world, one thing we learned is, hey, let's clarify that the emergency powers absolutely will apply in a public health crisis, as well as if there was a weather or windstorm event. And so that is a major part of what was done in 718, 719, and 720. It allows board and committee meetings, elections, and member meetings to be by phone or real-time video conferencing. You can notice those by electronic transmission. And you can restrict access to common areas and facilities based on the advice of public health officials as well. You can mitigate damage or contagion by removing debris and sanitizing. But it did include some limitations on these emergency powers. And this ties directly, again, as I see it, as very powerful real estate lobby. You cannot prohibit owners, tenants, guests, or agents from accessing common areas and facilities, obviously, to get in and out of their unit, or when access is necessary for the sale, lease, or transfer of title. This is subject to limitations on access. Like if there is a directive from a public health, the CDC or some other public health official that says to prohibit access or restrict access, then you can follow that. The board also can adopt reasonable restrictions on access. But if you don't have a ban on access, like a temporary hold on access, then the board's reasonable restrictions would not include, hey, we're not going to allow showings of units. That is something that's now going to be limited. You'd have to still allow units to be showed. What you can, in my opinion, reasonably restrict is you're not going to allow an open house during a pandemic. Hopefully we won't have another pandemic, but if we did, we're not going to allow an open house. You're going to have to require by appointment only, and we're only going to let a certain number of individuals in the building at a particular time, and they're going to have to require to wear masks, and you're going to be responsible for the expense of sanitizing the elevators, or different things like that, which again, you should be working with your management team, your business advisors, and running any of these rules, and quite frankly, any rule by your counsel, legal counsel, to help get the language correct and make sure what you're doing is within your authority, and avoid legal challenges as best as possible. But those emergency powers effective July 1st will clarify going forward that the public health crisis will be included, and that'll eliminate a lot of the confusion, or at least that some people had. Okay. Couple of very quick things on cooperatives. You cannot require a member to state a purpose to inspect records, and cooperative board and committee meetings can be done by telephone, video conferencing, or similar communication methods with board members present, being present that way, counting toward quorum. That's just what happens all the time. We have changes to 718, usually first. 720 will follow suit, and then 719, they're like, wait a minute, we need to make changes here as well. So a couple of these are just catching 719 to be in compliance and read in unison with chapter 718 and 720. That's what those two items did, because those requirements have already been in. Well, the requiring members to state a purpose, as I mentioned earlier, has been in the HOA Act. So they added to the Condominium and Cooperative Act that if an individual makes a proper request to inspect records, you can't deny them if they haven't said why. They don't need a reason. The fact that they are an owner or the authorized representative of an owner is the only reason they need to inspect the records if they make a proper statutory request. And if you don't have reasonable rules in place governing inspection requests, then I encourage you to reach out to experienced counsel. If you don't have counsel, hire an attorney to help you draft these rules that the board can adopt to, again, it's not to prohibit people from accessing them, but it's to try to eliminate what we get a lot of, what I see a lot of is from the legislators who say, oh, we get so many complaints about denial of records. And I don't believe that, quite frankly, I don't believe that to be overwhelmingly the case. I think those are rare. Of course, what I hear a lot of is that there's people who are emailing every 3 days, access to records, and it's an overwhelming commitment for the association management team and for the board members, volunteer board members, and it can definitely have an impact on running the business. So that's why it's encouraged. The statutes on the administrative code allow you to adopt reasonable rules and regulations governing inspection of records, and you should communicate with counsel, and you should get those in place to make it more, to clarify everybody across the board. This is how you do it. And if you do it this way, no problem. You can come inspect, but it's not going to be a way that can just continually harass the management team or the board members. Okay, the next couple of items now specifically are for HOAs. I told you 630 is a big one. This is all still part of 630, all takes effect July 1st. Senate Bill 630. HOA rules and regulations are no longer defined as a governing document in Chapter 720. And why that's relevant is it means that rules do not necessarily need to be recorded in the public record, because the governing documents of your community association, in this case, we're talking HOAs, do need to be recorded. Your declaration, any amendments, your articles of incorporation, and any amendments, and your bylaws and any amendments all should be recorded in the public record to be effective. Prior to July 1st, the rules, and that was a recent change, by the way, a couple of years ago, they added rules, and some say it was inadvertent, added rules to the definition of governing documents, which then required all HOA rules to be recorded under the statute. So many HOAs have recorded rules. And I will offer to you, in my opinion, if you've been recording your rules and you make amendments to those rules, you should continue to record those rules. If for some reason you have never recorded your HOA rules, well, effective July 1st, you will not need to record them. So it is a business decision whether to record rules or not. You do need to publish them, meaning you need to be mailing them to the owners, whether it be mailing the rules, whether it be putting it in a newsletter, but you do need to provide the rules to the owners and have an affidavit of mailing on file confirming you've put them out there, post them on the property where you would post rules, because rules do not become effective until they are published. And that means provided to the membership. Okay, and it's not good enough to just say in the minutes, give everybody a copy of the minutes saying we've adopted rules. You need to give them the rules. Okay, any questions? Contact your attorney, get clarity, get clarification to make sure you're doing these rule process correctly, that your rules are being, the rules that you create or adopt are enforceable. They're not going to expose the association to liability. And so I encourage you all to do that. Okay, HOA meeting notices. The board can adopt a rule providing a procedure for posting meeting notice and agenda on a website or application. You also have to send notice to members whose emails are in the official records in the same manner as required for notice of member meetings. It's just an additional way to notice member meetings. They do finally clarify HOA official records. You must maintain for 1 year after election, voter meeting, all sign-in sheets, voting proxies, and all other papers and electronic records relating to voting. Okay, it's a 1 year after election. It was unclear before, it was not included at all. Election records were included in the Condominium Act and the Cooperative Act, were left out of the HOA Act. It was sort of in the catch-all. So some would argue you didn't need to maintain. Others said, well, it's in the if it's part of the catch-all, you have to maintain it for 7 years. This is clean. Now it's clarified. You attain, basically you maintain anytime you vote, especially an election vote, you're supposed to be voting annually. So those records are maintained for a year. Then when you have the next election, you don't need to maintain the prior year's election materials. I suggest to you that it is referencing any vote. So if you're voting on amendments, that you don't need to necessarily keep them for more than 1 year. But in my opinion, it's safe that you retain those records for at least 5 years. After 5 years, any challenge to an amendment as a statute of limitations has run, so they can't challenge the validity of an amendment. But before that, it's good to be able to have a record that's showing these amendments were properly approved and not just your minutes saying that they were. Okay. If you're in a gated community in an HOA, okay, there's a new category of record that you are responsible to maintain. However, it's not eligible for inspection. And I'll explain. So what you have to maintain is information that's obtained in a gated community in connection with guest visits to owners or residents. In other words, a visitor's log. You are required to maintain that. However, it is not something that an owner can demand to see as part of an inspection. Much like an owner's, any personal identifying information or attorney-client privilege, or medical information that you obtain for an owner who's requesting, for example, a support animal. And again, this is in the HOA gated community. You have to maintain your visitor log, but it goes in a separate locked box where it's not open to inspection by the owners. It's available there should there ever be information needed, but it's not part of the inspection. So just be aware, it's a record you must maintain, not open to inspection. Okay. There's been a change in HOA reserves. Now in the condominium world, you have statutory reserves. For the most part, it's pretty clear. You have to maintain, the statute requires certain reserves must be maintained in every budget unless the membership votes to waive or partially fund. The HOA Act, in the HOA world, statutory reserves were only in place if the developer had created them, or if the membership voted. And based on, well, I'll offer this. in my opinion, the way that the new legislation has been drafted might need a little bit more attention in 2022 to be clear on it. But what it appears to me and what it appears to the attorneys in my firm is that in an HOA, the only way you'll have statutory reserves is if the membership votes by a majority of the voting interests to create reserves, statutory reserves. And what statutory reserves means versus just quote reserves, statutory reserves means that you are required to include them in the budget unless the members vote to waive or partially fund. And if it's a partial fund, then you're still required to include partial funds. And if there are reserves in your accounts, you may not use the reserves that have been for a purpose other than for which they've been reserved, the designated purpose. So if you had reserves for a roof, you couldn't use those reserves to go paint your building without a vote of the membership if you're doing a straight line where you have reserves specifically designated for a particular item. That's what it means with statutory. If it's not statutory, then really, quite frankly, it's more discretionary, meaning the board would have the authority to use those funds for a proper purpose, not just for whatever they wanted, but for a proper purpose. They wouldn't be tied to needing a membership vote to use them. And as you can tell, this is something that obviously has legal implications. So please do not burden your manager. Ask your manager to be who gives you this legal guidance. Ask your manager to get with your legal counsel or get legal counsel to give you guidance on whether you have statutory reserves, whether you need to fund reserves or how you fund reserves, and whether if there are quote unquote reserves in your budget, are they truly statutory reserves or are they more discretionary in nature and perhaps should be renamed? And your CPA can be involved in that as well. I'm speaking of the HOA specifically here, not the cooperative, not the condominium. Okay. And then the last item I want to talk about in 630 is the leasing. And this has to do with homeowner associations. Okay. By way of information, in the condominium world, back in 2004, there was a bill passed that said if a condominium is going to approve amendments that either prohibit leasing or restrict the length of time or the number of times you can lease, those amendments will only apply against any owner who voted in favor of those amendments or any owner who took title to their unit after that amendment had been passed and recorded its effective date. That's been in the law in the condo world for 16, 17 years. The last 3-4 years, there's been a very big push by the rental community, the long-term and short-term rental communities, to try to get similar legislation in the HOA world. And we at FLA have aggressively pushed back. I'm understanding they have about 30 to 40 lobbyists. We have our one, but we have a couple other groups we work with as well. So there's about 3-4 groups that we work with that we've been trying to keep that out. And we've been successful in years past. Unfortunately, this year, there was someone in the legislators, higher up in legislators, who were going to get this bill passed. And the bill would have been very similar in language to what was in 718, which in my opinion is just not a good language. And so we were at FLA able to get a carve out. So I will explain the law and then I'll explain the carve out. Okay. Any governing document or amendment that's enacted after July 1st, 2021, which is next Thursday already, after July 1st, 2021, if it prohibits or regulates rental agreements, it will apply only to the owner acquiring after the date of the amendment or an owner who consented to that amendment. Very much like we have in 718. This is now going to be in 720. Okay. So that's the law. The carve out is an association may amend to prohibit or regulate rentals for a term of less than 6 months or prohibit renting 3 times in a calendar year, regardless of whether, and if that passes, that will apply to everyone, whether or not the owner voted in favor. So again, a long-term lease, a long-term lease restriction, like a lease restriction that tries to prohibit leasing for 6 months or more, that will only apply if the owner voted in favor or an owner acquired title after the effective date, after July 1st. But if the amendment is to prohibit short-term renting, no, you can't rent, if you want to say you cannot rent for less than 30 days to eliminate people being able to rent week, that type of amendment will apply across the board against everyone, even if the owner didn't vote in favor or a new owner takes title. So that's important distinction. And that was the carve out that we pushed to get compromise. And by the way, just to a little understanding of, if we had not compromised here, as my understanding is, this particular bill was going to just go on its own. This HOA leasing would have been passed as a single bill, gone through, and the rest of our stuff, which I think I've talked about a lot of good stuff, wouldn't have passed. So we were agreeable, we negotiated, they compromised, we put it in the bill, and we all agreed to push forward and get the 630 passed, which it was, and signed by the governor. So you take the good with the bad. And in this case, at least we watered down the bad, in my opinion. There is another piece to this, though. Whereas in 718, it just says if you take title after the effective date and there's nothing more. In 720, there is a change of ownership exception. And it talks about there's no change of, it's not going to be considered a change of ownership of the parcel if it's conveyed to a, quote, affiliated entity. And there's a statutory definition of affiliated entity, which is very comprehensive, very comprehensive. And however, so you're going to obviously need to communicate with your counsel. Again, guys, please don't ask your management team to be the one interpreting this. It's just not appropriate or fair. But if you have a question that after July 1st, if you do adopt an amendment that prohibits long-term leasing, and it does pass, and then down the road, there's a change of ownership and the owner's claiming, I didn't vote for that amendment. And by the way, this is also why administratively you should be retaining the votes so you can show who voted and also who didn't. So if someone claims down the road they didn't vote for it and you have a record they did, you have a way of proving that. Otherwise, it becomes messy. So hold on to votes on these types of amendments for more than the 1 year. Hold on to them for long term. Also, there's no change in ownership if it's an heir that acquires title. So there are some limitations there. And by the way, if you're an HOA with 15 or less parcels, this doesn't apply. So that's a pretty big bill. And I'm sure there's going to be some questions on that. And I will get to that. I want to touch base on, and guys, as you can see, this is a summary. At some point in time, we'll have the legal update, which is 2 hours plus, and we'll be able to spend a little bit more time talking about these and answering questions. And I'll be doing them via Zoom. I'll be going out and doing these in person as well, and hope to meet a lot of you who I haven't met and see a lot of familiar faces. So Senate Bill 602, that's what we have for 630. Senate Bill 602 took effect May 7th. This has to do with business organizations. And it basically clarifies that any conflict between Chapter 617, which is your Not-for-Profit Corporation Act, and Chapters 7, 18, 19, and 20, the Condo Co-op and HOA Act. It was amended to further emphasize that provisions of the Florida Condominium Act, Florida Cooperative Act, and the Florida HOA Act will control when there's a conflict between the Florida Not-for-Profit Corporate Act, which is 617, and those community housing statutes. Or if there's something more specifically provided in the housing statutes, the housing statutes will supersede. Also, it clarified last year, if you did my 2021 legal update, we talked about committees and what they clarified with advisory committees versus executive committees. And when you had a committee that had the authority to take final action on behalf of the board for the association, that it had to be made up of at least a majority of persons who were on the board. Well, this also further clarified that unless otherwise provided in the bylaws or articles, only certain committees that take final action on behalf of the board can be comprised of a majority of persons who are not directors. And these are these will make sense. Committees include the Architectural Control Committee, a Compliance or Fining Committee, an Impartial Election Committee, and an Organizing Committee if you have to revitalize your documents, and that's in an HOA, and that has to do with the Market Record Title Act. And if you have not heard of MARTA and you are an HOA, then when you get off this webinar, please contact your counsel and ask them, hey, does MRTA apply? Are we impacted by MRTA or are we covered? A simple line like that. Your attorney should know what that means. I can just let you know if you're a client of this firm that it's a 30-year situation. And if we have, when we have documentation, we start notifying you 27 years out. But if you're not sure whether you're work with me or whether you work with another firm, I'd reach out to your attorney now and ask about MRTA. HOAs only, not the condo, not the cooperative. Okay, but those, so that's it. So if you are a committee, architectural control committee, a compliance or finding committee, an impartial election committee, or you're on the organizing committee, you do have the authority to make decisions on behalf of the association. However, you are not required to have a majority of the board of directors run that committee. Okay, how are we doing on time? Okay, okay. I have two more bills that I want to talk about then. Well, three more bills that I want to talk about. One, I'm just going to simply mention that I think you should take a look at, and I don't have time to go over it today. But the two other bills I want to talk about are Senate Bill 1966 and then Senate Bill 56. Senate Bill 1966 also was signed by the governor. It's effective July 1st, 2021. Again, these were all just signed within the past week. It takes effect next Thursday, July 1st. And it has, it's a fairly large bill, but there's only two items within the bill that I believe needs to be mentioned during this presentation and quite frankly, during the legal update. The first is the eligibility of a candidate for a condominium election. And by the way, this is a DBPR bill, which means these apply to the condominium and the cooperative perhaps, but not the HOA. So the eligibility of a candidate for a condominium election is based on being delinquent in assessments only. So in the condominium world, what it used to say is in order to have your name on the ballot, you needed to you could not be delinquent in quote, any monetary obligation to the association. Well, that was revised for some reason. I don't know why, I didn't get an explanation, but now an eligibility of a candidate to be on the ballot, you can only be looking to see if they are delinquent in assessments. If they have other delinquent fees, fines, or any other monetary obligation, that is not what you're considering in determining eligibility. So I know that I've had situations where people were late, they had interest charges of literally pennies. And my experience is division upheld that means you were not eligible to have your name on the ballot if you just had a late fee. So what they're saying now is if you're delinquent in your assessments, you do not go on the ballot, but if it's any other obligation, you do. I do want to point out that if you are already a sitting director or officer and you become more than 90 days delinquent in the payment of any monetary obligation due to the association, then you are deemed to have abandoned your seat. So there is now a difference. If you are running for the board, you just can't be delinquent in your assessments. But once you get elected or appointed to the board, if you have a delinquent balance for more than 90 days in any monetary obligation, then you are going to be deemed to automatically have abandoned your seat. And even if you then pay up in full, you don't automatically get that seat back. The board would have to appoint you back. Okay, that's number one in Senate Bill 1966. The second item in Senate Bill 1966 clarifies a board is required to adopt the annual budget at least 14 days prior to the end of the fiscal year. Okay, a prior budget remains in effect until the new budget's adopted, which I think everyone understood. But now if you have not adopted an annual budget at least 14 days prior to the end of the fiscal year, and you fail to do that twice, that's going to be deemed a minor violation by the Division of Florida Condominiums. Why this has become important is, well, first of all, I will tell you that they originally drafted this to say if you fail once, it's going to be deemed a minor violation. And I can tell you that I personally push back on that on behalf of FLA and on behalf of all of us and all of you in the condo world, because the division has a new approach now, where the division used to say, hey, we're here to educate and point out, and if you're with the division, I say this with respect, but I believe that their shift has gone a little bit away from education and more towards penalty. And this is no secret, it's been discussed, that if you have a violation now, you don't get a quote smack on the wrist, you don't get a warning, at least not in my experience for the most part. Maybe in rare instances they are doing that, but for the most part you get a minor violation, and a minor violation can mean a $20 per unit fine or penalty, which you can settle with a consent order. But so if you're a 40 unit condo, you're paying $800 because you forgot to adopt your budget. or you failed to adopt your budget 14 days prior to the end of the fiscal year. So I did push back and I said, hey, at least give them one warning. So they did agree. And now if it happens, that's why it says if it's twice. So if for some reason it happens once and you get, told if you're reported to the division and the division confirms you failed to adopt your budget timely within at least 14 days prior to the end of your fiscal year, that will be your one warning. If it happens again, you're going to have a minor violation. Okay, so those are the two for 1966. The last one is Senate Bill 56. And again, my opinion, this is not a good bill. It did take effect July 1st. This was the one bill we really were trying to push the governor to veto, because ultimately it is going to be problematic for associations, I feel. The first part is that if the association sends out an account statement, then it has to be sent out by mail or email to the address that's maintained in the official records. And if you've been mailing these account statements or late notices, you can't suddenly switch and email them without, according to the new law, you can't change the method of delivery without giving 30 days written notice to the owner at their address of record, and having that owner affirmatively acknowledge in writing that they've received it and they accept that you're going to give a new method of noticing. As a practical matter, I just don't see that happening. And I'll tell you, quite frankly, what happened here is we had a member of the Senate who has a lot of power, who I believe had a personal situation where they were getting, if they were late, and I presume they had been late in the past, I don't know, but if they were late, they were told, they got a letter in the mail that said, you're late, you need to pay, or we're going to refer you to the attorney. And for whatever reason, the management company or the board or whoever was in charge changed their way of, maybe they saved money on mailing, maybe. They started emailing. I guess this individual was late again. They emailed them a late notice, and this individual didn't see the email. This individual in the Senate didn't see the email. And so the first notice that this individual got was a letter from the lawyer, and then obviously it added some attorney's fees. And because of that person's personal situation, we have now new legislation in the state. And the first part, I think, directly addresses that individual's concern is, hey, listen, if you've been mailing late notices, you can't just email me without letting me know you've switched the way of doing it. Okay. I mean, if you looked at your email, first of all, don't pay late. You have an obligation to pay on time. But I understand maybe sometimes someone misses one here or there, and I can, okay, so listen, if you're going to be changing the way you deliver, let me know. All right, not too unreasonable. But it didn't end there. It went further. So now, as of July 1st, a mandatory courtesy notice has to be sent 30 days before any collection action can proceed. Now, I will tell you that I was on the phone with staff for this individual. I was explaining to staff that my experience, and we work with quite a lot of communities throughout the state, and also speaking with my colleagues in this industry who work with many other thousands of communities in the state. And I think all of you here on this call, those of you who manage associations or even board members, you're probably sending at least one courtesy notice before you consider turning someone over, and maybe even more than one. And I explained this. I said, you are trying to legislate something that isn't an issue. And what you're going to do here is make it much more problematic, because you're going to create a statutory mandate for these notices. You're going to create some sort of form for these notices that, if it's not substantially complied with, is now going to give those owners who are habitually late or who want to avoid paying another procedural opportunity to claim defect, to challenge the ability for the association to collect what the association should be able to collect, which is past due maintenance. And unfortunately, it fell on deaf ears. And unfortunately, because of the position this individual had in the Senate, we were not able to stop this from becoming passed in the Senate, passed in the House, and signed by the governor, at least not in this session. So, so what we have now effective July 1st is a mandatory courtesy 30-day notice. As I mentioned, we put out an article, we did a blast to the general public. And if you're a KBR client, we did a blast directly to you as well. And we sent out a reminder. This takes effect July 1st. And to you management teams, it's important that you communicate with your attorneys and communicate with us if you work with us so that we can get on the right page, because what we don't want is for you to have a handful of files that the owners haven't been paying and you refer them to the office, and this 30-day mandatory notice is not in compliance with the statute, because then all of a sudden we have to then tell you, hey, this isn't right, you got to start over, we need a proper 30-day notice. And so that's going to just delay the ability to collect at least another 30 days. And obviously none of us want that, except for the owner who's not paying. And so what that's going to end up happening is it's going to, this whole process now adds admin charges, administrative time, in my opinion, to the association. And if you're managed, it adds administrative responsibilities to your management company, for which, in my opinion, it is reasonable for your management company to charge for that. And this was the argument I was presenting, and myself and others, is that, hey, there's going to be additional charges, and this is going to fall back on the association, because your management company is not proper to have to absorb it. It's going to fall back on the association, and who's going to end up paying that is all the owners of that association who are paying timely, not the individual who's not paying, because they're not paying. So, this was the position we discussed. It didn't unfortunately, logic didn't prevail here. So this mandatory courtesy 30-day notice has to be sent up for any collection action. There is a form that's in the new bill, Senate Bill 56, and you have to be in substantial compliance. You can only seek assessments, late fees, and interests. If there is, if the management company has an administrative charge for doing this, there's a debate whether that can be included on the letter. I think that it possibly could. An affidavit of compliance is required by whomever is sending out that 30-day late notice. So if you're self-managed, you need to have this affidavit. Management companies, you need to have this affidavit, and it's required to establish a rebuttable presumption courtesy notice was sent. So it's not, so you have to have the mandatory 30-day notice, and you have to have an affidavit that you've sent the 30-day notice. And those are things that are going to now need to be referred when you send the files over to us for collections, or wherever you're sending them. In addition, you're going to have to include now this mandatory 30-day notice in proper form and this affidavit of mailing in proper form. So I'm going to encourage you to get with your counsel and maybe ask them, or your counsel for, hey, can you draft a form that would be sufficient to you to work with? To me, that makes the most sense. That you have a form that in our case, we have a form we provide, and that you use that, and then this way that eliminates the issues. But I just want you all to know this is a problem. And it's to me, the only party that benefits here is the individual who is not paying. It does nothing for the association or all the owners who are paying. The other part of this Senate Bill 56, it does harmonize now. All collection notices are 45-day deadline. HOAs required a 45-day notice of intent to lien and a 45-day notice of intent to foreclose, where condos, and if you did the cooperative, it was 30 days. Well, now they've changed condo and cooperative to condos to 45 days. And that's, to me, again, that part also is not as big a deal. It harmonizes them, and that's fine. But do be aware now, you have a 30-day courtesy notice that you must send, not the law firm, and you cannot charge legal fees at all in that first notice. And then after that 30-day notice, then you have a 45-day notice of intent to lien and a 45-day notice of intent to foreclose. So at a minimum, you have 120 days pre-suit. So nobody is rushing to foreclosure here, and that doesn't include time for mailing and setting up. So you're looking at easily, 4 months of the collection, the pre-foreclosure process, the courtesy trying to get before you go to the attorney. And so my other suggestion here is those of you who had a 2 or 3 courtesy notice process, where you gave 10 days, 15 days, 30, and then another, whatever, I think you need to reconsider. I think now that you have a mandatory 30-day notice, you might reconsider and do a simple 1 courtesy notice in compliant with the statute. Make sure you work with your counsel to make sure you have a compliant document, and adopt a new policy. But that's Senate Bill 56, in a nutshell. The only other bill I wanted to mention, guys, and I thank you for the time, Senate Bill 76 has to do with property insurance. I'm not going to spend a lot of time on it, other than it defines specific terms and actions that are prohibited in insurance practices, including prohibiting advertisements, soliciting, interpreting policies, or advising on insurance coverage. there's a lot of specifics. I would absolutely encourage you to reach out to you all have good insurance agents, and get with your insurance agent. Ask them if they could just clarify for you the impact Senate Bill 76 has or doesn't have. I think a lot of it may impact associations, also might impact you individually. So, and in an HOA, if you're an owner in an HOA, you'd want to contact your carrier and find out how this impacts you. I can tell you personally, I got a notice from my HOA carrier claiming that this is somehow going to help not increase my rates. I don't know if that means it'll reduce my rates, but we'll see. But I just want to mention that's Senate Bill 76. You can take a look at that and get with your insurance agent on that. So, all right, so we done not bad, Mark. We did it. It's about an hour. Guys, as you can see, a lot of information was provided, is in there. If you guys want, I can take, Mark, I can try to skim through the questions, see if there's any I can quickly answer. If that, we have time for that?
Yes, we absolutely do.
Okay.
While you're looking at it, Michael, I liked everything you said except for Senate Bill 56, because from an accounting standpoint, it's horrendous for us.
Yeah. Well, and you know, and I just want to point out it is, and the big issue there is because one of the items on that form is interest. It says assessments, it says late fees, and it says interest, and you have to indicate also what the interest rate is. And my experience is most communities don't charge interest at the courtesy notice stage. You know, they'll notify, hey, you have a payment and a late fee if you're entitled to charge a late fee. If they don't pay and it's referred to my office, then, you know, pursuant to the declaration and the statutes, we charge interest going back to when the date that it was first due. Now there's this concern that if you don't indicate interest on there, you might be waiving the ability to collect it, which is why I encourage, you know, we were talking internally about this yesterday, and we're encouraging our clients to get with us because, you know, so that there's a way that you can properly address the form so that you might lose the ability to collect interest for the first month, but you don't want to lose the ability to collect interest throughout the whole process. It's not substantial money, but on certain accounts it could be. And ultimately, if it's the owners who are not paying, and that's what gets me the most. It's the owners who are not paying who are benefiting from this bill. And the other thing, like I said, and I don't think I'm speaking out of turn, and I'm sorry if the individual doesn't like it, but the Senate president, and who I believe is responsible for this, and if I'm wrong, then I apologize, but I believe, and it's my understanding, it's my opinion, that it was the Senate president who had a personal situation and now legislated the state on this, and over legislated, I should say. Because like I said, I think certain things that I agree with, I think that you shouldn't, the individual received notices by mail, you shouldn't just switch to email without giving him a heads up. But to now require the statutory 30-day notice when everybody was doing courtesy notices before sending it to the lawyer, and now putting in, you have, you know, because from the law firm side, you know, if we have to make sure these things are done 100% correct, because you're going to have these cottage industry lawyers who are going to try screaming Fair Debt Collection Practices Act because you didn't do it right. And it's going to delay things. It's going to delay things, and that only hurts the associations. And that's what we were trying to implore the governor, but unfortunately it didn't work. So we will be working on seeing if we can clean this up in 2022. But for now, effective July 1st, this takes place. So I'm suggesting to all of you here now, if you're putting out if you're going to be referring matters for collections, because July 1st is next week, I would start doing these 30-day courtesy notices now, so that by the end of July, you're ready to turn files over for those owners who are not paying.
Nice.
Tom, the statute number for subrogation amendment, that was part of 630, Senate Bill 630. Marcia, is there any reason a records request cannot be provided via email? Is there any reason it couldn't be? There's no legal reason it couldn't be. I would suggest that in some instances, it may not be how you want to be providing documents, and you should communicate with your association counsel as to the pros and cons of providing record requests by email. Tara, please confirm the association can go after the unit owner to recover their deductible amount when the unit owner's unit is the source of the incident, no matter what provision is stated. Tara, I think what you're talking about in the condominium world is there is a provision in 718.111 that does say if the owner was negligent in causing the damage, the association does have the ability to ask the owner to reimburse, which would be including, and the deductible would be reimbursable. But the association has the burden of proving the negligence, so it's not automatic. Luann, I'd like to see that amendment before I confirmed, as we have a recorded amendment states no more than 4 consecutive years. Does this new rule override amendment? I'd like to see that amendment be able to provide guidance on that. Shelley, I'm sorry, I don't know what your question is asking. Timothy, I have a question about how an association can go about recertifying an amendment to the association documents that's not been enforced for 20 years. Timothy, there's a process called republication. It is something you should communicate with experienced counsel on. If you have association counsel, get with them. If you don't, I know a good one. Barry, I know you love those Kaufman language questions. We're not getting into a Kaufman discussion today, but thank you as always for listening. Stephen, I think I answered your questions. Okay. Mary, when a new resident's approved, we have them fill out an emergency contact form. On the form is a question that reads, do you authorize the association to send you notices to this email address? The form is signed if they mark yes. Is that adequate to send the meeting notices by email? Mary, I would recommend that you be more clear on there, that you indicate to them, can we use your email as an official, as the official, as the place for notices, and let them know that by indicating yes, they are agreeing that their email will be part of the official records. I think then you're in a better place to be able to confirm that. Application fees, Tony, only apply to the HOA if your governing documents talk about it. There is nothing in 720 that talks about application fees as of today. Mary, same question. Does the transfer fee legislation apply to HOAs? It does not. Ben, does the partial term served in 2018 count as term number 1? July 1st, 2018, if you are elected or appointed after July 1st, 2018, that is when your consecutive, that to me is when the time starts. I suggest, Ben, that if this issue is still in place in 2025, give me a call. Melissa, I'm not sure when you're asking there. I'm sorry about transfer applying to management companies. Mary, transfer fee is really what a screening fee is. It's a transfer fee and it can be increased to 150. Well, listen, if your governing documents say a transfer fee of $100, then you can only charge $100. For instance, so when we amend documents, we will say you can charge a transfer fee in the highest amount allowed by law as it may be amended from time to time. That would be that's the way to properly do it. So that if something like this happens and you can now go up to 150, the board can simply by a rule say, hey, we're doing a 150 transfer fee. But if your documents have a specific dollar amount for transfer fees, that's all you can charge. So get with your attorneys and find out what you can and cannot do. Teresa, you said something about a membership meeting only requiring 4 days notice. If it's an HOA and it only requires 4-day notice, that is possible. It depends on what the meeting is for as well. So you'd want to have I would recommend that you ask the manager just to get an opinion in writing from counsel to confirm. Tara, I just answered your question. If the deck says 100, you can only charge 100. You have to amend the deck. Alberto, is the association allowed to charge a renter a yearly fee for a background check? I would need more information on that. From the way you're asking, it doesn't sound like you could. Again, hey, Matthew, nope, transfer fees are only in the condo world, in the condo statute. HOAs, it applies if it's in your governing documents. Teresa, good question. Is the transfer fee same as capital contribution? One of the condos has been continuing to charge 2 months of monthly assessment fee amount when the unit was sold new or resale. The condo community turned over in 2017. Transfer fee is the capital. Okay, my opinion, capital contribution is not a transfer fee. My opinion, unfortunately, is not the division's opinion. The division believes that if a transfer fee caps at, in this case, 150, that incorporates any fee you would charge at the time of a sale. So at the time of a sale or purchase, if you are charging a capital contribution that exceeds $150, that's a violation of the statute. And if someone complains to the division, that is the position that they have held. We've tried to get, in fact, when I talked earlier about how we had modified the provision to say to charge the actual cost of the invoice, we also clarified that this does not, a capital contribution does not apply. And unfortunately, that didn't get ground. We'll keep trying on that. So no, be aware that the transfer fee is capped at 150, and that includes, and if it's a capital contribution and the division becomes aware of it, then they will cite the association. Oh, Stephen, thank you for bringing this up. One thing I didn't mention, for the charging stations, there is a provision in 630 that also now says that if the association, the board wants to approve installing a charging station in the common element area, that it is not considered a material alteration and you do not need a member vote. So the board can then go ahead and put a charging station in. So Stephen Weber asked, if an association wants to install a charging station in a common area parking space, the association can do it and it's not a material alteration. The answer to that is correct. The statute was changed to say that it is not considered a material alteration. No vote of the membership is necessary. That said, that does not then allow you to say to an owner who wants one in their own parking space, sorry, we're putting one in for everyone. You can't have it in your parking space. The owner still can have their own if they follow all the proper protocol. But so thank you, Stephen. I meant to mention that, so you helped me out there.
Michael,
Yes.
a question on the charging stations. If a community puts it in, who bears the cost of the electricity?
Again, I would imagine that the way you'd put it in is you'd want to try to set it up so that the individual is the one paying for it.
Right.
I'm not an expert on that, but I don't, but I believe that there is probably ways to do that where the individual using it is the one being charged for it as they use it. In order to use it, they'd have to pay. Okay, guys, we're running out of time. I'm trying to get through as many of these as I can, as you can see. Where a condo, does our board need to pass a resolution to increase the transfer fee, assuming we have the authority? Yes, Stephen, the board should, if the board is going to increase the transfer fee and you have the authority to do so, and it's not specifically mentioned in your documents as a flat number, then yes, at a properly noticed meeting of the board. And by the way, I was gonna say, because you're talking about addressing the sale or lease of a unit, that rule would impact the use of the unit, or potentially could be argued that it does. And unfortunately, in that regard, it should be a 14-day notice that the board's going to be adopting a rule governing regarding transfer fees. That's on the agenda. It's posted and mailed to all owners. And then you do that, and then you notify the membership that this has been changed. And obviously, on any sale or lease application, it should be noted in there as well. So it confirms it. Hi, Violet. Can residents request the employee records such as compensation, salary, or otherwise with no employee contract? There are specific restrictions. There are confidential records, and so it's from the way you've written your question. Employee records, I would say, they are not open to inspection. The contract, the association's contract, the management contract, or an employee's contract. If there is no management, it's just self-employed. I believe that contract would be open. And certainly budget items, which would indicate salaries for compensation, but not like payroll records and things of that nature, no. Serena wants to know the proper way to request review of documents. It depends on if your community has adopted reasonable rules and regulations, but written request to inspect the records is basically the way to go. Not a demand for copies, a request to inspect. Joe, please distinguish what needs to be amendment to the declaration versus a rule that is not. Unfortunately, that's a question that's going to be fact specific, case specific, and something you'll have to probably pay your lawyer to assist you with. Dino, term limits, again, I'm just going to say there is no term limit until 2026, and so I don't think we need to spend time on it right now. Mark, when making major changes to your rules and regulations that have been council approved, I applaud for that. Is it required the rules be mailed to your owners when the 14-day board meeting notice goes out? No, it is not. You do not need to mail the rules out at the time you send the notice. You send out the notice with the agenda item that indicates there's going to be rules considered at the meeting. The board would review the rules. In fact, I would suggest even reading the rules, discussing them. Membership can have input, of course. And so you might have copies of the rules at the meeting, or if it's via Zoom, maybe have a shared screen. And then at the end of the day, the rules are approved, maybe approved as amended during that meeting. And then it's those rules that have to be mailed out afterward, affidavit of mailing confirming when they went out. Debbie, the gate log is an HOA statute. It is not, it was not in 718, it was in 720. Can a condominium board impose new or altered rules without a majority membership vote? Joanne, that's going to depend on what your documents say. Most documents do allow the board to adopt rules without member approval. I have clients that require a majority member, 75% member. So it really depends on your documents. Patty says, if our governing documents already prohibit rentals, does this impact us? If you have language in place in your governing documents, that's going to control. It's not going, this is not going to change that. Michelle, does this touch short-term leasing restrictions? I don't know what that means. Sanford, that amendment will remain enforceable. That short-term lease. Steve, would the order of payment application be affected? I think you're talking about with regard to, I think you might be talking about the eligibility to be on the ballot. I'm not sure, so you'd have to clarify, but it's something that is unclear. Maria, can you define monetary obligation? Monetary obligation would include a fine. So if you're a sitting board member and you have been fined and you don't pay that fine and you have a balance more than 90 days, you are now off the board. But a fine cannot be used to keep you from being on the ballot. Teresa, 14 days minimum before the end of the fiscal year for your budget to be adopted to avoid a violation. Serena, yes, if the fine is, the association pays the fine, so all owners are technically impacted, yes. Tom, yes, that mandatory 30-day courtesy notice is for everyone. Not just condo, it's HOA, and if you're doing them for co-ops, it's for co-ops too. James, does this impact those who've already received notices already in process? My opinion is it shouldn't. The law doesn't even take effect yet. I'm just saying if you have not sent out a courtesy notice yet, because we're a week away, I'd recommend following the statute now. Shelley wants to know what happens if you send the notice via email and regular mail, but mail gets returned, email does not. Does it count? Okay, well, there is statutory requirements for how mail has to be sent. It's certified, regular, etc. And so, no, if you send, I mean, if the regular mail gets returned, that's troubling. But you're also supposed to send certified. So I would say, Shelley, that's something that you're going to have to talk to your counsel about more specifically to find out why regular mail is getting returned. The mandatory courtesy 30-day notice is for all, Rosario, for all. Stephen, I don't, it's a good question. Does the association need a resolution, the 30-day courtesy notice? When you have a collections policy, if you already have if you have a policy in place that you've adopted that indicate we're going to send out courtesy notices, my opinion, it's a good idea. What I mentioned is yes. Modify your policy, adopt a resolution that indicates we're going to be sending a single 30-day courtesy notice in compliance with the statute. And thereafter, if you haven't paid, you'll be referred to the attorney. I think that's a good idea. Shelley, where can we download the affidavit form? Via website or a council draft for us? I don't know that there's a website. I think that the council that you're working with for collections is probably the best person to go to and ask them to prepare us a one-time, like I said, we would do. We prepare a one-time form that you can use for your particular association as a work product. You only need it once, and then you can just make copies of it. Barbara says, is address of record for mailing still the address listed on the property appraiser's site? Address of record can be the property listed on the property appraiser's site. Barbara, obviously address of records is also the address that the individual has provided to you. The address of record should be the address the individual has provided to you. Matthew, 56 does apply to HOAs. Perry, thank you very much. Stephen, thank you very much. Thank you, thank you. Dino, Raul, Sue, thank you. Dino needs interest rate and dollar amount. Senate Bill 56, Dino, you're going to need to, I would say, get with your attorney counsel, get guidance. What you can do is, like I said, if you go to kbrlegal.com, we have a legal morsel that was recently sent out that you can find on there that talks about Senate Bill 56. Next month, guys, the Florida Community Association Journal comes out. Jeff Rembaum has an article that talks about all these pieces of legislation as well as some others. Bell, to confirm, did you say the rate of interest should be on the 30-day notice? That's what the statute provides. The rate of interest is supposed to be noted on the 30-day notice. I encourage you all to look at Senate Bill 56 and see the form there. And I think the best thing to do is to get, like I said, I think you do get with your management team, get with your counsel, get a form you guys can work with.
Michael, just a real quick interjection. This is Jeff. This recording, so many of you asking about the recording of this video, it'll be on the cargforhelp.org website as well as the firm website. And then the Senate Bill 56 article that Michael just referenced with the legal morsel article, that link is now in the chat for you all as well.
Okay, and John, I know you have to go. And again, I mentioned this up top, and I know it was also, I'm glad everybody appreciated the class, but this is not a class for manager credit. This is education only. The legal update, which is the 2-unit LU class, is a class that has to be approved by the division, which will be, and we'll be providing it. But this was just a 45, 50 minutes, which now obviously I'm going over just to answer more questions. But so you're not going to lose any credit. And thank you for listening as long as you could.
Thanks for answering as many questions as you have. We all appreciate that. And I know the audience does too.
You're welcome. And I realize you guys have other things to get to. So I am going to say, guys, I know I could be here all night and day and night, and I know you'll keep answering questions. And I just want to thank you all for the kind words. And yes, Jeff, you're welcome. But I realize as I'm saying this, that you guys all also, these sponsors of yours for CARG are the reason I'm here. And I want you all to hear what they have to say and support all your sponsors. And again, if KBR can be of assistance to your community at any time, please feel welcome to email at info@kbrlegal.com or call 954-928-0680 or go to our website and use that for free resources as well. And stay well and stay safe, everybody. And I'm going to jump.
Michael, before you jump, there was one important question that they went ahead and said, are you taking on new clients?
We absolutely are. We are taking on new associations. If anyone's interested, they can email me at info@kbrlegal.com. info@kbrlegal.com.
And there'll be a very, very brief survey at the end of this as well that some of you have already filled out. And if you were seeking more information from Michael or any one of us, simply state it on the survey as well.
All right. Well, Michael, I want to really thank you on behalf of CARG and the attendees, obviously. I mean, it's a wealth of knowledge. That's what I started off to say, that, you know, it's not something, I mean, you just were almost able to shoot right from the hip and we're spot on. And I mean, it was a tremendous amount of information that we all had to digest. And you really did a terrific job to try to break it down for us. So
I try to speak slow too. I know it's hard. I'm still a New Yorker.
Right.
All right, guys. Well, everybody stay well. I look forward to seeing everybody. Mark, follow up.
All right, terrific. Again, thank you again.
Terry, always good to see you as well. And I don't know who else is. I see Marcy's image. So hi, Marcy. Charles, to you as well. Stay well.
Thank you. You as well.
Okay, guys.
Care,
and
Michael,
everybody who stayed on, so don't jump off yet, people. There's more good stuff coming your way. But I want to thank everybody and enjoy the weekend.
Bye-bye. Take care. So for those that are still on, we have some of the members of CARG. We have Charles Infantina from GRC Landscaping, which obviously with the hurricanes coming up, with the tree trimming, you may have questions for him. You have Terry Russo from Center State Bank. Now it's called South State Bank, okay, but they still provide the same services. And especially now with hurricanes coming up, it's very important, at least from an accounting standpoint, that I always advise the clients to get a contingency line of credit if they don't have adequate funds to support deductibles from insurance. Marcy is on from Cable Consultants, which she usually always goes ahead and gets the best services and also saves a boatload of money usually. So if anyone really has a question, and I forgot, and then there's Jeff Solomon, who obviously is the spearhead really of this group that handles all of our IT and our Zoom calls, and he's available for any associations or managements that want to put on a professional, Zoom conference.
Mark, there's a question. There's a question here real quick for Charles. Charles, GRC Landscaping, Teresa has a question. How can you be reached? They might be interested in your services.
You could either reach me directly on my cell phone at 954-242-8815, or my email address at charles@grcservices.com.
Thank you. Sorry for the interruption. I just came across it. Didn't want to miss it.
No, that's quite all right. And, last but not least, obviously doing monthly accounting for associations, we want to make sure that you start getting prepared for budgets. It's coming up soon, and especially with the new legislation, we want to be able to go ahead and have a timely adopted budget. So with that, if anyone has any questions, we'll continue with the questions and answers, the Q&A, and then our panel can go ahead and answer any questions. Or if you want to speak to anybody, obviously how CARG operates, it's a free service to talk. We'll spend as much time as you need to go ahead and to explain our various disciplines. Just taking a look if there's some questions here. There is a question. Charles, this is with landscaping basically. In light of the hurricane season upon us right now, what do you recommend as far as with tree trimming? As far as 1 year, 2 years, minor cut, major cut?
Well, normally, depending on the size of the property or the association, a lot of the associations that we currently service, the board usually likes to do the palm trees twice a year, once before hurricane season, and again, a second time before the holiday season. Hardwoods are generally once a year, again, in June, starting anytime from April through June, July, for your what we call a pre-hurricane tree trimming, where we go up through the center of the tree, remove all the dead branches, cross limbs, and create an open path for air to flow through the canopy of the tree. So twice a year for palm trees, once a year for hardwoods, and depending on how big or how old the hardwoods are, you may be able to do it every other year.
Terrific, I appreciate that. There's another question, really, this is concerning banking for Terry. If you can unmute Terry when you get a chance. They're talking about contingency lines of credit, which I had mentioned before, as far as the time that it takes to go ahead from start to finish, and what the contingency lines of credit can be used for.
Well, the line is in place for 2 years. The line of credit can be used for hurricane damages, community improvements, any kind of emergencies the community might have, and also your insurance deductible. As far as an amount goes, the amount would probably a starting number would be your insurance deductible and go from there.
All right, terrific. And I know Brandon Levy's not here from Legacy, but
Right.
Specifically talking about insurance deductibles, and this is very important for everybody. The insurance has gone up dramatically all over the country because of reinsurance. So I tell all my clients that they really should have a deductible, because at times you can go ahead and you can reduce your your deductible amount, or have a higher limit, I should say, which will save on a yearly basis a tremendous amount. And with the contingency line of credit, you can still be protected, God forbid, of an emergency. But if you take a look at the last few years, if you go ahead and you save $20,000, $30,000, $40,000 a year, you can imagine the savings the association has by having a contingency line of credit in the event that you need it. So it's probably, pardon the pun, is probably the cheapest insurance that you can go ahead and an association can have. Another question is for Marcy from Cable Consultants. Marcy, can you unmute?
Yes, I can.
Hi, how are you, Marcy?
Good, thank
Marcy, you know, people are really, there's a question here that really, they really don't know what a cable consultant does. You know, and I know that
Okay.
I tell all my clients to go ahead and to get together before, way before, probably 2 years before the renewal of your cable contract. If you can maybe just explain a little briefly, like what your company does and what services you provide.
Sure, I'll do it very quickly. A lot of associations have a bulk cable program where the association pays for the television and or the internet for each one of the residents. If you have that, I can help you look at what you currently have and see how you can possibly lower your rates and get more services included. And Mark was correct. You can start looking at that even a couple years, 2 or 3 years ahead of when your expiration date is. So if anyone there has this type of program, a bulk program, reach out. My number is 954-225-9500. Or my email is mg, my initials M like Mary, G like girl, at communitycableconsultants.com. But very important, there are people that don't have bulk agreements and they can still have tremendous benefits from doing an agreement with a cable provider. That's nothing more than an access agreement. It doesn't bind the association to anything, but it does give the association a big fat upfront check sometimes, some free services for the clubhouse, and some upgraded wiring.
I can
on their,
attest to that.
Yep,
Thank you,
on their
Marcy.
property. So anyone that is part of an association, whether they have a bulk or not, should look into what options could be available for them.
All right, and also, and Marcy, I'm talking a little out of turn, so correct me if I'm wrong, but in my experience with all my accounting clients, the fees are paid normally through the cable company. So your service, unlike probably every other service, is practically, and I use that a little loose, but practically free to the community.
Right, I actually help bring the community money and not really take it back from them. So it is really a good idea to look and see what's available because it's typically not a charge to the community for any help.
Right. Okay,
Thank you.
terrific. Then there was one other question, which actually is for me, doing monthly accounting. We don't do any auditing. We only do monthly accounting. We do the, we pay the bills, we collect the monies, and we give financials on a monthly basis. There was a question is how often financials should be given to unit owners. My opinion is on a monthly basis. It should be timely. And those records should be available to every single unit owner and all the board members, because you have to remember that, you know, like a condominium or an HOA or a cooperative is a business. And without the financial statements and without comparing it to budgets, you really have no idea, you know, where you're really going, whether you're spending too much, too little. And again, with budget season coming up, those are the financials that will help us prepare and a good solid budget for the community. So I'm available for any questions. Please, you know, reach out to CARG, that's CARG, the number 4, and then help, HELP.org. We will go ahead and provide everybody, all the other panelists and the CARG members with their contact information. I'm just checking if there's any other questions right now.
Yeah, we had one. When should year end? This is for you, Mark, from Teresa. When should year end financial be sent to the membership?
Well, there's actually statutory requirements for year end and especially for audits. I don't want to really burden everybody, but again, we provide financials on a monthly basis, so that year end financial everybody receives in January. As far as audits, you have statutory requirements that if you have an audit, or review, that those year-end financials will be getting to you within 4 months, basically. And you can get together with your auditor as if you're taking an audit. And just keep in mind, as far as with audits, that the board must approve a budget with fully funded reserves, and the auditing requirements or the reserve requirements can only be dismissed or reduced by a membership vote. The board is not allowed to go ahead and to say, we're not doing reserves, for argument's sake. That's strictly a board, the budget has to be approved, and it can only be changed by a membership vote. So thank you for that. I think that's basically all the questions. Do any of the other panelists want to say any other few words before we go ahead and let everybody go for lunch?
Just want to mention that on the CARGforhelp.org website, which is also how you could reach each one of us, by the way, if you ever need anything. Doesn't cost anything to send us an email and inquire or ask us a question. That is where the video from today, the entire presentation with Michael Bender as well as ourselves, will appear there within a couple of days. So that's CARG4Help, the number 4, CARG4Help.org. You'll find the video there, as well as our calendar of our next event to be advertised to you all very, very soon. And in the brief survey that pops up, please do indicate what else you'd like to see us present, whether it's for credit or not, because we do a little bit of both. Like today was not for credit. But as soon as we have a legal update course approved by the DBPR, which is usually end of summer, early fall, we will be sure to bring one to you as well for your legal update credits. But CARGforhelp.org. Mark, that's what I wanted to mention. Back to you, sir.
Okay, and really, and last, which we really don't dwell on enough, is really, we want to thank Jeff for going ahead and setting up the Zoom conference, and he's available for management companies and for board members to go ahead and to do a proper Zoom call. There's so many times that I get onto a Zoom call that Jeff is not handling, and it's just a debacle. And it just,
I'll pay you later for saying that. Thank you.
No, but it does. I mean, everybody on can attest to it. Even this, we went on for 2 hours and it was picture perfect, and that's really due to Jeff's expertise on that. So anyway, without continuing on, again, I wish everybody health and especially in light of with the COVID going on, and again, our prayers and condolences to
Surfside
people that have been affected from Champlain Towers. It's just a horrendous situation. And I know that CARG will help out whatever we can do, with the neighboring buildings or obviously with Champlain Towers. So again, thank you again. Have a great day. Take care.